Deal in the matter of Novartis AG and another, and Teva UK Limited and others.
Yes, Mr. Chairman.
My Lord, we've handed up a revised chronology, which is agreed between the parties, which
Thank
we
you.
should have on the desk, and that goes into, I think it's tab 7 in the core bundle.
Thank you.
And my Lord, there are certain materials which are confidential and marked as such in the supplemental bundle. Some of these are subject to a 3122 order from Her Ladyship below, but there are some additional materials, just transcripts and so forth. Core tab 5, supplemental tab 16 and 18, and we would ask for at least a pro tem 3122 order in respect to those.
Indeed, we'll make the usual order. If you could please cooperate to draw that up and lodge it, that would be of assistance.
As my Lords will have seen, this is an appeal from decision of Mrs. Justice Bacon, by which he declined to grant an arrow declaration. And we say the learned judge misdirected herself by wrongly identifying and applying a legal principle. The principle being that the Patents Court will not grant an arrow declaration where the sole or dominant purpose is to use that declaration in a foreign court, unless there is a compelling justification. And the learned judge identified that principle by examining the case law, in particular a decision of Mr. Justice Henry Carr in Fujifilm and ADV, and the decision of Mr. Justice Burse, as he then was, in Pfizer and Hoffman and Roche. And we say that there is no such principle. And by identifying and applying this test, the learned judge misdirected herself and therefore failed to exercise the broad discretion which was given to her. And in particular, she failed to follow the framework given in Financial Services Authorities and Rourke, which has been approved by this court. We'll come to that. And then we, of course, say that if the learned judge applied the correct legal test, she would have exercised her discretion in favour of the applicant. Before turning to the case law, my Lords, I was going to deal with the events that led up to the application. Fingolimod, Galenia, the trademark, is used to treat relapsing-remitting multiple sclerosis. And it's an important product worth $2.8 billion worldwide, and it's Novartis' second biggest selling product in the UK with annual sales of 46 million. The infringement proceedings, I make this point because the infringement proceedings, if successful, would be valuable either way by way of an injunction or by damages. Fingolimod was approved by the EMA on the 17th of March 2011. Data exclusivity expired on the 22nd of March 2022. The SPC for the product having expired before that in October 2018. We were concerned with a second-tier dosing regimen patent, and the claim is in the supplemental bundle at tab 2. I could just ask my Lords just to look at that if I haven't done so already. And it's the compound so that you've got the two features that matter is a daily dosage of 0.5 milligrams orally, that's in the second line, and then that chemical name is fingolimod. And use in treating relapsing-remitting multiple sclerosis. And the prior art, the three pieces of prior art that were pleaded in this case, and the prior art disclosed a clinical trial using that dose rate. And there are three pieces of prior art, and our case was and is that dose rate is obvious in in the light of the three pieces of prior art. Now, as my lords appreciate, one of the unsatisfactory aspects of the patent system is that an application can spawn divisional applications, and this can happen repeatedly. It's sort of reminiscent of that poem, great fleas have little fleas upon their backs to bite them, and little fleas have lesser fleas, and so ad infinitum. And so it is with patent applications. They can give rise to divisional applications, and those divisional applications can spawn more divisional applications. And this process can be perpetuated until patent expiry. And this creates uncertainty for a company legitimately seeking to introduce a generic product into the market. Here we're dealing with a patent with a priority date of the 25th of June 2007, and my clients are tormented with a new patent application being unexpectedly granted this year. My lords, the background is perhaps best seen from Mr. Sharp's witness statement. I'll just show you a couple of paragraphs of that. They didn't make it into the judgment, although they're not controversial. So that's at tab 5, supplemental bundle, tab 5. And if we go to paragraph 3.8, first, in fact, go before that, 3.4, sorry, I beg your pardon. So there was a parent application filed in June 2007, you see that at 3.4. And there was no limitation to dosage in any of the original claims. And then the claim is originally set out there related to neoangiogenesis. And then in March 2009, the claims were amended, and there were various doses put in there, wide ranges in that case. You see that in 3.5. Then turning over the page, you see the first divisional was applied for, which is the 154 divisional, was applied for in September 2013. That's the first sentence, paragraph 3.8. And then if you go to the end of that paragraph, you see the application was deemed withdrawn in May 2016. And then there was a second divisional, which is the 894, which was filed in July 15, so now we're under a considerable period after the original priority date. And at 310, you then see on June 2016, claims were amended to claim the use of the S1P receptor modulator for use in RRMS at a daily dosage of 0.5 milligrams per os. So that's when that first appeared, integer. And then at 312, on the 19th November, 894 was refused by the examining division for lack of novelty. And then the matter went to the TBA, you see that at 313 on the 22nd of December. And it was sent back on the 8th of February. TBA allowed the appeal with reasons to follow, and it's sent back to the examination division to be granted. And then just dropping down to 318, one also notes there's a third divisional in the pipeline, although the examining division has advised that it was deficient. The proceedings before the TBA, of course, were ex parte. Subject matter was held not to be obvious on the basis of some technical arguments, which we say were just wrong. And had it been an inter partes hearing, we anticipate there would have been a different result. If we can then, my lords, if I can ask you to go to the chronology. That's the background before we get to matters in the UK. The chronology tab 7, the one I just handed up. My lords, recall the TBA decision was the 8th of February, and then we see at the start of the chronology, we pick it up on the 25th of February. Teva, my client, commenced proceedings. That was for a narrow declaration. That was followed a week later with Novartis commencing proceedings for infringement. And on the 2nd of March also there was an application for interim injunctive relief in this country, and there were a number of defendants set up there. On the 17th to 18th of March, that application was heard before Mr. Justice Roth, and at the end of the hearing, the relevant defendants, including my client, gave undertakings not to supply pending the judge's decision. That decision came on the 26th of April. See that in the next bullet point. And then the next sub-bullet point, second sub-bullet point, Mr. Justice Roth ordered a prohibitory injunction against the defendants, so that was ordered on the 26th of April, preventing supply, subject to those caveats. And then on the permission to appeal was refused. On the 29th of April, Novartis sought permission to appeal to the Court of Appeal, and that was ultimately refused by Mr. Justice Burr on the 25th of May. So undertakings and injunctions or injunctions were in place from the 18th of March to the 25th of May, which is just a shade under 10 weeks. The interim injunctive relief was sought on the basis of particular representations as to the application, and I wanted to look at those. That's in the supplemental bundle, tab 19. So this is the supplemental bundle, tab 19. This is the skeleton argument before Mr. Justice Roth. And just picking it up, for a number of representations were made. At paragraph 10, what is certain, so this is my own friend's skeleton argument, I should say Novartis' skeleton argument. Paragraph 10, what is certain though is that the patent will be granted at some point over the coming months, and once granted its effect will be to extend back to the first publication, the application to 894, and then at 34, paragraph 34, we just see at the end of that paragraph, in short, it is a matter of certainty that 894 will grant without amendment to the claim of the main request. And going to paragraph 106, serious issue to be tried. In addressing this issue, it's fair to acknowledge that on one view, Novartis' claim is based on the more unconventional procedural route premised on the court's jurisdiction under Section 37 of the 1981 Act. However, it's fundamental to Novartis' application that it will soon have a patent of fixed claim wording which the defendant threatened to infringe, which once granted will have retrospective effect in relation to the period between publication of the application and grant. So it was the basis on which serious issue to be tried. And then at 108, there is no doubt that the defendant's generic fingolimod falls within the scope of the claim of the patent as it will, in italics, be granted. And similar representations were made in oral submissions. One sees that on the next tab, tab 20. We'll go to page 13 of that transcript, line 7. My Lord will also have appreciated that there is a patent which is about to be granted, protecting the market for Galenia, that is referred to as 894. The point about this patent is that we certainly will have patent protection. There's no doubt about that, but various administrative steps need to be carried out by the EPO. There was then abandonment of the UK designation of the patent after service of evidence of fact by Novartis, and there was abandonment of the UK designation on the 10th of August. Novartis has made clear that it will not explain why it's abandoning its UK patent, and it's claiming privilege in its reasons. The position's been made clear both in correspondence and before the court. And we submit that given the representations made, that it is to the court to get the interim injunction, that is odd and we would say rather unsatisfactory. The patent was granted on the 12th of October 2022. Grant was immediately followed by application for preliminary injunctions in other EPC states, as we anticipated, including Germany on the day of grant. Hearing of the preliminary injunction in Germany is in 2 weeks' time, that's on the 15th of December. Pursuant to the order of Mr. Justice Mead for directions on this matter, the question of declaratory relief has preceded the trial, the technical trial of obviousness, and is proceeding on the basis that we succeed in that technical trial of obviousness. Novartis has indicated it will play no part in that technical trial. The skeleton is already drafted, the evidence is settled a long time ago, and it's unopposed, it's not a complicated case. There was discussion before Mrs. Justice Bacon as to how it would be heard, and she indicated it might be appropriate to deal with it on paper. Alternatively, we proposed a hearing of up to half a day to deal with any matters that may not be clear on the papers, but it's a relatively concise matter at this stage. When their lordships were contemplating the balance of convenience test in American Sign Language, in my submission they may not have had in mind the parade of divisional applications which now march out of the European Patent Office. All no doubt said by a patentee to raise serious issues to be tried, all creating commercial uncertainty. And we say that having sought, in this case, interim injunctive relief under that jurisprudence on representation that this patent will grant, and that there is a serious issue to be tried, there is something distasteful in Novartis submitting that this court may make no rulings in respect of the subject matter of that patent now, which might embarrass Novartis in other jurisdictions. The reality is patentees are tactical in the way they approach enforcement of second-tier European patents. They pick their battles. They seek interim injunctive relief where and when it suits them to do so. They duck and dive, and they retreat when they don't want an adverse decision to preserve their position in another jurisdiction. The courts have seen this in other cases, and we have an example of that behaviour here. We have a patentee who, with much indignation and bravado, sought interim injunctive relief in his jurisdiction. He was enthusiastic to embrace this court when it suited it to do so. And now, a few months later, without explanation, it abandons its patent application. It seeks to shield that patent in order to avoid an adverse ruling by this court. And we infer to maximise its chances of obtaining preliminary injunction in other jurisdictions, including in particular the largest jurisdiction, the largest market in the EU, Germany. And therefore it suits us to say that my lord's hands are tied in that case. These proceedings serve no useful purpose, and but in reality we say the termination of these proceedings are an important aspect of its strategy. And if Novartis is correct, and this court should not have regard to the realities of what is happening across EPC contracting states in these sorts of situations, then of course patentees will be further emboldened with these sorts of tactics. We submit that arrow declarations are one of the tools the defendant has to temper these tactical games, and this is an example of a case where they have a valuable role. Finally, my lords, before turning to the case law, I just need to show you a couple of paragraphs, again, which are we make no criticism of the judgment in respect to them. They're just a little bit fuller than was in the judgment, and for good reason. And the first one is a witness statement which is confidential, so I'm not going to read it out. I'm just going to direct my lords to it. My lords will appreciate it's the identity of country A that is particularly sensitive, in addition to some of the commercial procedures my client has in place. So if I could just ask my lords to read, so it's tab 6, a witness statement from Claudia Kuller, who's commercial portfolio product manager at Teva. If I could just ask you to read paragraphs 2.3 to 2.5. My lords, the next witness statements, same witness, just paragraphs 2.4 and 2.5 in the next tab. Short passage. And then finally, my lords, just a couple of paragraphs in the witness statement of the expert report of Dr. Walters Hearn, so tab 8, in respect of German law. And if I could just ask my lords look at paragraph 3.1, she points out the leading case law of the highest German civil court, Federal Court of Justice, decision of 15th of April 2010. The name of the case, provides that it's necessary for the German courts to take into account decisions of the European Patent Office or other national courts, which essentially concern the same issues, and if the German courts reach different results from those of the EPO and other national courts, if appropriate, they have to address the grounds that led to them that different results. And then just turning over the page, 4.2, a German court, when deciding whether or not to stay the infringement proceedings or when considering an application for a preliminary injunction, does not hear a technical expert. In preliminary injunction proceedings, procedure not possible to have formal evidence, e.g. appointing an independent technical evidence. These proceedings are supposed to be quick. And picking it up at 4.4, however, German infringement courts will consider the prior art and decisions of the EPO and of other courts from EPC contracting states as part of forming a view as to whether or not there's a high likelihood that the patent issue will be invalidated. And then an example is given, a Copaxone example. I think it was a decision of my Lord, Lord Justice Arnold below, I think that was considered, and this was on an application for a preliminary injunction. So we'll see, no criticism of the judgment in dealing with that evidence. It's just explains the background to it.
Can I just ask you, Mr. Turner?
Yes.
Excuse my ignorance. Does Brexit have any impact on those matters?
No, I don't think so. I mean, the fundamental question is, of course, that the European Patent Convention is independent of the EU and those instruments. The Commission doesn't like it and has tried to grab hold of it a few times, but it is the convention.
But it continues post-Brexit in the same way.
Yes.
So reference to national courts in the German decision would include the UK court.
It would, yes. We may enter another chapter in future with a unified patents court,
Which we have not got yet.
But we've not got there yet. And then I was going to turn to the case law, if I may. I was going to start, because all sort of routes these days lead back to Messier Doughty. That's at tab 7. It was reasonably brief. And there has, we say, been a recognition of the utility of declarations, and moving into negative declarations was one of those points in the development of this area of the law. And it was a judgment of Wolf's Master of the Rolls at the stage. And go to paragraph 41, discussion of the Camilla Cotton case. It just says, Lord Wilberforce and Lord Denning differed in the circumstances of that case as to whether the declaration would serve a useful purpose. However, if it would, then it would be the appropriate to grant a declaration was agreed. The approach is pragmatic. It is not a matter of jurisdiction, it's a matter of discretion. The deployment of negative declarations should be scrutinised and their use rejected where it would serve no useful purpose. We just stress that we see it again and again. It's no useful purpose. It's not a high hurdle. However, where a negative declaration would help to ensure the aims of justice are achieved, the courts should not be reluctant to grant such declarations. We're not, of course, concerned with negative declarations here, but the same point arises, and it's the same dominant consideration we say, at least the starting point for a declaration. Is there a useful purpose, or is there no useful purpose, to be precise? And the aim, as always, is to do justice between the parties. I was next going to go to, because this gets picked up in a judgment of this court, a judgment of my Lord Justice Floyd in Fujifilm. The first instance, this was an interlocutory appeal in Fujifilm and Abby, and really concerned fundamental questions as to the jurisdiction for arrow declarations. The concern being that they might tread on the toes of the Patent Office, if I might put it that way, and that's what much of the discussion is about, which we don't need to revisit. But I wanted to pick up a couple of passages in this. The first is at paragraph 60, the reference to financial services authority law, and which the court agrees with. It says, and this is citing Mr. Justice Newberger as he then was, it seems to me that in considering whether to grant a declaration or not, the court should take into account justice of the claimant, justice of the defendant, whether the declaration would serve a useful purpose, whether there are any other special reasons why or why not the court should grant the declaration. But we also need to look at this decision for other purposes, and I wanted to go to a submission that was made at paragraph 73. Paragraph 73, you see Mr. Hobbs making certain submissions, and I wanted to focus on Romans 6 on the facing page. This was a device of advocacy being put forward to the court. To allow declarations in that arrow form would be to open the floodgates so that a claimant faced with patent problems in, say, Romania could come to the English court for a declaration that a product is obvious, because it would be useful to him in connection with his business there. That was the submission. And it's touched on by this court at 95, page 154 of the bundle. We are not persuaded the declarations in the arrow form will open any floodgates. The arrow decision now has some age, not result in many such cases. The circumstances in which such declarations will be justified, we would have thought to be uncommon Mr. Hobbs' example of a business problem in Romania would be unlikely to justify the grant of a declaration by the English court. So we describe this below as a sort of vanilla example where there's no dispute in the UK, the dispute is in Romania, the commercial concern is in Romania, and if an applicant were just forum shopping and say, well, I'd rather have a decision in the English courts, which I can then apply in Romania, that would be a potentially floodgates issue. And this court, and we don't disagree at all, said that it would be unlikely to justify a declaration on that basis. And we agree that our declaration should not be an opportunity for forum shopping. So if a case at the outset has no connection with the UK, that may be a reason for declining the declaration. Of course, this case is not that example. It's not the example which the Court of Appeal were touching very briefly upon here. Because here, of course, the jurisdiction of the UK courts was being sought by Novartis. They're not a forum shopping case.
Well, in that submission, you emphasise the position at the outset of the proceedings. But why should it make any difference if a case which initially does have a connection with the UK thereafter ceases to have a connection with the UK?
Yes, I think it may come in part to the analysis by which one disposes of the Romanian case. So the vanilla Romanian case never had anything to do with the UK, and it could be declined on a number of reasons. It may not be the appropriate forum, so if the defendant is not in the UK, there'll be a forum non-convenience argument. Also, it may be an abuse, and that's what I was going to come on to deal with next. And neither of those defences, if I can, defences is the wrong word, but I would appreciate what I'm driving at, neither of those reasons apply in this case. It's not said that this case is an abuse case.
Well, I understand that, but to take the 2 points you've just made, if there's an objection of forum non-convenience, or it's decided the case is an abusive process, then one doesn't get to the question of whether there's any basis for exercising the declaration. The discretion doesn't arise.
Yeah. Yes, my lord, that's right.
So one has to presume, first of all, that there's in personam jurisdiction over the defendant.
Yes.
Firstly.
Yeah.
And secondly, that the proceedings are not an abusive process.
Yes.
And then one gets to the question of how should the discretion to grant a declaration be exercised.
So in my submission, that would deal with the Romanian example. Now, if one had got to trial, and the Romanian example had, for maybe to the incompetence of the respondents, the abusive process point had not been taken, or the forum point had not been taken, it was before the court, then one could look at the special reasons. So Mr. Justice Neuberger's test, or the Messier-Doughty test, I'd also go back to it in paragraph 60 of this case. There would be a useful purpose, and I'm going to come back to the useful purpose. But are there special reasons? And one could say, well, a special reason in this case is this has never had any connection with the UK. And it would depend on the particular case. So those are the 3 devices one would have with dealing with Lord Justice Floyd's Romanian example.
Well, I understand that so far as it goes, but I'm still not clear why you say it makes a difference whether there was a connection with the UK at the outset, if there has ceased to be a connection with the UK.
So I'm not obviously going to come and develop this, but looking ahead, what we say is there is a useful purpose in this case. I have to persuade you as to that. What is going on overseas supports a useful purpose. So I've succeeded in showing there's a useful purpose. Then one's on to special reasons. And as a special reason, I will say the fact that the consideration in my Lord's discretion is the fact that Novartis has come to this court and sought to engage the jurisprudence of this court and made representations to this court, and is plainly just shielding its the judgment this court would otherwise reach, would be a special reason in this case, which wouldn't be a special reason in the remaining case. So, my lords, that's where we're. But I wanted to just spend a little bit. That's the analysis I wanted to. But spend a little bit longer on the cases just to make that good.
You presumably have the benefit of a cross-undertaking in damages against your undertaking an injunction that was in place. Is that not sufficient compensation to you for being injuncted temporarily?
Well, it will be limited to the losses. It will be argued it's limited to the losses in the UK. So what we're concerned about is that a patentee just taking its chances, just saying, right, we'll try and get an injunction in the UK, haven't got one, we'll tell the court this is going to grant, now we're going to pull it. And that's going to maximise our chances in another jurisdiction. And this is a game, I don't say game in the trivial sense, it's a very important
just
commercial
stopping there, I'm sorry, I haven't understood it.
Yes.
You say bringing a UK application for an injunction, which in the event was unsuccessful, say for temporary holding injunctions, increases their chances of getting injunctive relief in other countries?
So what would happen in the normal way is that matter would proceed to trial. If it had been a granted patent, let us say, the defendant would have to submit to revocation. If it wanted to get out of those proceedings, it would have to submit to revocation. Now, it doesn't want to do that in this case. In fact, it has got an alternative. So it's withdrawn the UK designation. So what was one of the unusual aspects of this case is that it was a patent application. And it was seeking an interim injunction on the basis of the patent application, which is rare, if not unprecedented.
Well, to be sure, but that's just a factual aspect of the present case, which is unusual. But your case would be no different if, in fact, the application for the injunction had been made after grant.
If, broadly speaking, yes, but there is a nuance here because, of course, there's not an equivalent of being able to just remove the designation. My learned friend, if it had been a granted patent, my learned friend could have tried to surrender it, and that would have led to a different type of argument. My Lord will have in mind the Connaught case where Mr. Justice Laddie said, no, this close to trial, I'm not going to make you surrender. You have to submit to revocation. So, sorry, I may have not have answered my Lord's question. So the position we're on is that had this matter proceeded to a judgment, had Novartis remained good to its representations that this patent was going to grant, we would have had a judgment of this court. And by avoiding a judgment of this court, it's seeking to play jurisdictional games and going to Germany, where it's going to rely in Germany on the German equivalent to American cyanamide, go to an infringement court where they don't have any technical evidence. It would be very convenient to Novartis not to have a finding from the UK court with respect to the obviousness of the subject matter. And that maximises its chances now of an injunction in Germany. So it sees Europe as a playing field, and it ducks and dives and it picks its battles, and it seeks to shield the consequences of its action from shields its patent application, the subject matter of its patent application, from a judgment of this court, precisely because it wants to get these benefits. And the decision my lords have to make in this case is in all cases is this court going to play along with the play along we're going to enable patentees like Novartis to play that game, or will it look at useful purpose in the broader sense, as we submit it should, and enable defendants in appropriate cases, not saying in all cases, but in appropriate cases, to say, no, having got this far, there's no abuse, there is a useful purpose. Providing it's proportionate to do so, the court should grant a declaration. So that's the issue I think has not been decided before.
Thank you.
My lords, I was going to go on to Jamil. Because this is a route which it's not being pursued. My lords may well be familiar with this case. I was going to pick it up at 57, and this was, if you recall, this was concerned alleged libel, which was published on the online version of the Wall Street Journal. And I think it had been only accessed by 5 subscribers in the UK, and one was the claimant solicitor, I think. So it's a very limited publication in the UK. And the question was that an abuse? And if we pick it up at 57, there's a reference to the earlier Schellenberg BBC case. Mr. Justice Eady, that's in the sort of second sentence, struck out this as an abuse of process. He rejected the submission that he should not do so, as this would deprive the claimant of his constitutional right to trial by jury. He says, I see no reason why this case requires to be subjected to a different pre-trial regime. It's necessary to apply the overriding objective, even in those categories of litigation in particular, to have regard to proportionality. Here there are tens of thousands of pounds of costs at stake and several weeks of court time. I must therefore have regard to the possible benefits that might accrue to the claimant as rendering such a significant expenditure worthwhile. He added that the overriding objective's requirement for proportionality meant that he was bound to ask whether the game is worth the candle. And he concluded, I'm afraid I cannot accept that there's any real prospect of trial leading a tangible logistical advantage. And that was that case, but that's what gets picked up by the court in Jamil, and it's really at 64. They refer to the Berezovsky and Michaels case, and then at 64 make reference to the dissenting judgment. It was allowed to proceed in that case. Dissenting judgment of Lord Hoffman, and so the notion that Berezovsky, a man of enormous wealth, wants to sue in England in order to secure a precise determination of damages appropriate to compensate him, being lowered in the esteem of persons in this country have heard of him as something would be taken seriously only by a lawyer. And then just picking it up at 65, says the plaintiffs are forum shoppers in the most literal sense. They have weighed up the advantages to them of various jurisdictions that might be available and decided that England is the best place in which to vindicate their international reputations. They want English law. And then the next quotation, my lords, I do not deny that some respect an English court would be admirably suitable for the purpose, but that does not mean that we should always put ourselves forward as the most appropriate forum. And then 66, they say, so far as concerns the issue currently under consideration, there's no conflict between the view of Lord Hoffman and the view of the majority. The action falls to be considered relating exclusively to an independent tort, a series of torts in this country. And at top of 67, we see it wasn't a declaration that was under consideration here. They say, to what extent will this action, if successful, vindicate the claimant's reputation? English law and procedure does not permit the court to make a declaration of falsity at the end of a libel action. And at 69, if the claimant succeeds in this action and is awarded a smaller damage as it can, perhaps be said that he will have achieved vindication for the damage done. And the cost of the exercise will have been out of all proportion. So it's very much taking the approach of proportionality. The game will not merely have not been worth a candle, it will not have been worth the wick. So that's was the governing consideration. So So we would say an application for declaratory relief must serve a useful purpose, and if it's not worth a candle, if it's not proportionate, it may be stayed or struck out as an abuse, and abuse of process was not pursued at trial in this case, and was not the basis upon which the learned judge reached her judgment. Again, just to remind my lords, it's of note that the validity proceedings are unopposed, will take either be done on paper or take up to half a day. The idea of spending a day and a half before Mrs. Justice Bacon arguing that it's not proportionate to spend half a day, of course, never really made sense. So this was never about proportionality. Quite the opposite. This case is extremely important to both parties. Before turning to Fujifilm and Pfizer, I just wanted to remind the court that it's widely recognised in a number of decisions on validity that decisions of this court may impact what happens overseas, and that is a legitimate consideration. These courts do not operate in a silo, and this court has recognised that, as indeed has the patent court. And we see statements to that effect in a number of cases. I just wanted to remind you of what Mr. Justice Arnold said in TNS and Nielsen, so my lord, in your first instance. And that's at, I think, tab 14. And can I just invite you to read paragraphs 23 through to 26.
But that, of course, is a case where the question was whether it was an abuse of process
Yes.
to pursue a claim to invalidate a UK patent.
Yes. Yes, it was. Yes. But we say that the courts have been cognizant of the effect that the UK judgment might have on another jurisdiction. The courts have not historically closed their mind to such matters. And when seeking to, we're not at the outset of proceedings here. We are at trial, and indeed we are working on the assumption we've already succeeded on the technical arguments. So that's the assumption on which this is based. And so, given that questions of proportionality don't arise, and that the parties have both sought to employ the jurisdiction of this court, what we ask rhetorically are the reasons for not granting a declaration at this stage of the proceedings, having got this far. And that is by saying that it is appropriate in this case. One is not envisaging, in a Romanian example, that it will be proportionate or indeed appropriate. So, my lords, then if I could perhaps get to the meat of it, which is Fujifilm and Pfizer. We can pick it up at 346. So this is after the Court of Appeal. You looked at this is a later decision. This is a trial. And there were, I don't think we need to go into any detail, but there is. Starts at 346, and the background to the various patents are described. So the 656 322 and 491. 656 was surrendered almost straight away, and 322 and 491 closer to trial. And there was also, you see at paragraph 353, a reference to the de-designation of what was called the fourth division, which was an 044 patent. I'm not sure the details of that background need to be picked. But I wanted to pick it up at 359. And this is where Mr. Justice Henry Carr placed reliance on the fact that the chief executive of AbbVie was essentially threatening infringement. There had been no attempt to sue for infringement in the UK, but the chief executive was sabre-rattling, not specifically for the UK, but made worldwide sabre-rattling, if I may put it that way. And so there was no infringement proceedings in the UK, as much as I had in mind. And then if we go to 367, see a reference to Nokia. The judge quite rightly gives a citation. This is from Mr. Justice Pumphrey. He says the principal factor affecting the exercise of a court's discretion, apart from such matters as the sufficiency of the description of the device or system to which the invention is said to be essential, is the utility of the negative declaration sought. Would the declaration, if granted, be the legal equivalent of shouting in an empty room, or is there some point in it? So, leaving it aside for one moment the jurisdictional aspects, there's always been the threshold for useful purpose. There's always been low. It is a purpose of some sort, a useful purpose of some sort, as opposed to being purely academic or abstract. And this is another way in which it's put, is it shouting in an empty room. And then if we go to 372, we see a reference to spin-off value of judgment. Spin-offs often put in speech marks. It's not a term we particularly embrace, as it sort of suggests something of lesser consequence, but I think we all know what we mean. And again, very similar to what my Lord Justice Arnold had said in the earlier case at 374, see Mr. Justice Henry Carr saying, I accept the spin-off value of a judgment in a contracting state can be very valuable, and it's legitimate for parties to rely upon such judgments in other contracting states. It's important not to extend that principle too far. Statements as to spin-off value in UK judgments have been made in the context of application to stay pending resolution of EPO oppositions, application to trial. Those cases are very different from the present. It's also important to guard against forum shopping, where a declaration from the UK court is sought in cases which have no connection with this jurisdiction. And then it's at 377. The judge cites the passage we've looked at from the Court of Appeal in Fujifilm, and we say he really takes it a lot further. He says a declaration which is sought solely for the benefit of foreign courts will rarely be justified. So he's extended that proposition beyond the less emphatic wording and the vanilla example given by the Court of Appeal. And in our submission, he's without deliberately, he's sort of almost inadvertently gone further, perhaps, if I can make that submission, in paraphrasing what the Court of Appeal had said in that case, which he then cites.
So do you say he's wrong when he says, I am concerned with whether it will serve a useful purpose in the United Kingdom?
Yes, yes. And the Court of Appeal, going back to the Lord Justice Floyd in FKB, the Court of Appeal was just not concerned with proceedings which were legitimately started in the UK and where a defendant is ducking and diving in the way we say Novartis is in this case. And indeed, it was just this very light example, an example which must be right. We all recognise it can't be right that you just, we've got a dispute which is solely connected with Romania, you start suing in the UK. We all instinctively know that doesn't make sense, which is, of course, why Mr. Hobbs was using it as an example. People were saying, well, that's
why? What I'm not following is why in the present case we're not equally seized of a case which is solely concerned with a foreign jurisdiction now?
Well, my lord, now, now,
Yeah,
that's right.
you say that makes all the difference.
We
And the
say,
fact that you can't wipe out the history, even though there will be no infringement in the UK and the patent will never exist.
yeah, we say there is a useful purpose. So we're going to come on to Mr. Justice first. We say there is no rule of your law that useful purpose has to be useful purpose in the UK. That's certainly not established in the authorities. I'm going to encourage my lords not to establish that in this case. That's the position.
Do you have any example of a case where the sole useful purpose was outside the UK?
Yeah, well, there is an example coming. Yes, in the next case. Yes, I mean, it's which was considered by Mr. Justice first. That's what we say. So we satisfy the useful purpose test, and then as my learned junior reminds me, we've also got the question of the supply chain, which we mustn't lose sight of. Which, so this isn't just a case of...
Well, your supply chain from as it were, the borders of this country is safe. So it's the supply chain abroad which this court has got to be concerned with.
Yes, but if there's an injunction in country A, supplies to the UK will be disrupted. So that's an aspect which is different. Not an answer to my question, why is it different to the Romanian example? That is a difference. But I'll just carry on with the authorities and try and bring this together if I may. So then 386. Mr. Justice Henry Carr is saying, I do not accept AbbVie's submissions, and I accept the claimant's case on this issue to the extent set out below. If, as AbbVie submits, the declarations have no useful purpose, and the steps that they have taken have the same effect in achieving commercial certainty, there's no coherent explanation as to why it refuses to submit to judgment, alternatively given acknowledgement in the same form as the declaration. The suggestion that AbbVie resists the declaration because it does not accept the relevant dosing regimes or anticipate or obviousness does not withstand examination. If that were the case, AbbVie would have abandoned its UK patent protection. Had it maintained that, would not have abandoned UK patent. Had it maintained that protection and won the trial, would have been able to stop the launch of the claimant's biosimilars. In my judgment, AbbVie would not have invested the considerable resources that this trial has required unless there was a good commercial reason to resist the declarations. In the absence of any alternative explanation in the evidence, I believe that the declarations would be more damaging to AbbVie's strategy in relation to Humira patent portfolio than the complex set of undertakings and abandonment of UK patent protection that it has chosen to provide. And we make a very similar observation in this case. Then picking it up at 397, the judge makes reference to the threats. And then, of course, we've got actual sued and interim injunction in this case. And picking it up at 401, I also considered that the declaration would serve a useful purpose in protecting the claimant's supply chain for the UK market. He refers to Mr. Inman's evidence. And then he's explained that as a practical matter, 5 lines at the bottom, due to the international nature of the industry, most biosimilar manufacturers will be unable to confine their manufacturing supply chain to within the UK, so the UK market may not be able to be exploited without a risk of these patents in other jurisdictions, and makes reference to some evidence, and then some evidence of Dr. Gilbert, and then at the end of 404, it says an injunction obtained at any of these locations could disrupt the European supply chain, including supply to the UK market. Dr. Gilbert has been informed that SB Biden's plans for launching SB 5 in the UK will follow the European supply chain. The evidence goes beyond spin-off value to assist the claimant's products to be made in other jurisdictions. It explains how the grant of a declaration will make injunctive relief in other jurisdictions less likely and why this will be of direct benefit to the UK market. So that was something that he placed reliance on. But absent that supply chain, he was not as persuaded, and he picks it up at 411. As I now turn to the question of spin-off value, the claimants submit that the declarations will be influential in other European courts and tribunals. And then 412, he says, I accept that the spin-off value of a judgment in a contracting state can be very valuable, and it is legitimate for parties to rely upon such judgments. However, on reflection, and having regard to the legal principles which I set out above, those are in our submission, the misinterpretation of my lord in the earlier case. I've not taken this into account, other than to the extent that the issue may have an impact on the UK market. So the judge doesn't place reliance on that.
What do you say his reference is to the legal principles which I have set out?
I think it's back, my lord, to the Court of Appeal, which is at 377, which is the bit you can say he got wrong.
But is it not also a citation from Jamil at 376?
It probably is, although Jamil was, of course, not concerned with declarations, not concerned with our declarations, and was concerned with abuse.
It was concerned with whether it was a proper use of the libel courts in the UK to pray in aid the effect that a decision of an English jury might have in vindicating him in relation to publication elsewhere in the world. Yes. The Court of Appeal, picking up on what Lord Hoffman had said that that was not a legitimate.
Indeed, it wasn't worth a candle, I think is how it was put. It wasn't worth a candle in the UK, which is why it was struck out as an abuse.
Well, I mean, my question was, what is your submission as to what Mr. Justice Henry Carr was referring to when he says he's had regard to the legal principles he set out?
I think he was principally referring to 377, but I accept he was also referring to Jamil.
Yes. Thank you.
And so we're going to come on to what I think that's right. I think he's also referring to Jamil. So the start of 377 says this, among other authorities, shows that when considering whether to grant the declaration of president and concern whether it will serve a useful purpose in the United Kingdom, and we submit that that's not the law, and we'll go on to Mr. Justice Burst in the next case. So that's Pfizer, that's at tab 2. And again, similar and dissimilar, different in the sense that there was no attempt to sue in the UK. in Pfizer, the patentee had not sued in the UK, and there's no claim for infringement, nor had there been an application for interim injunctive relief, and so it was the applicant who was seeking our declaration to use in Belgium, and similar in the sense that the patent protection was abandoned. And there were disputes as to the legal principles which apply, and I think this may answer my Lord Justice Nugee's question. So if you go to 64, the parties do not agree how these principles are to be applied. In summary, counsel for Roche submitted that, and this was the respondent, the court has no jurisdiction to grant declarations where there was no dispute about UK legal rights or disputes of facts that were relevant to the UK legal rights. In the alternative, if that argument's failed, there was a hard-edged point of principle that precluded the court from granting declarations in such circumstances. Useful purpose test, see FSA and Rourke, therefore related to a purpose that was useful in the context of the UK legal dispute. And then continuing further, in the alternative, in any event, the circumstances in this case do not justify declaration for two reasons. First, because in fact there is nothing in Roche's conduct to date that justifies exercising jurisdiction as a matter of fact. And then we can pick it up, I think, at 82. I was just going to pick it up in the middle of 82, there's a reference to Fujifilm before Mr. Justice Henry Carr. There's more nuance than that. This court could readily grant a simple declaration that Roche has no right arising from the defined patent family to prevent importation into the United Kingdom of a relevant product. But the reason that that is true is because of the de-designation. However, that is not what Pfizer wants, nor is it what Roche is resisting. And then dropping down to 84, he's referring to the judgment of Mr. Justice Henry Carr. He says, I agree that the use of the UK patent judgment in other contracting states of the EPC can be very valuable. It's legitimate for parties to rely on a judgment in that way. However, the judge also said, and I also agree, this cannot be taken too far. One needs to take into account the risk of forum shopping, where a declaration is sought from a UK court in a case with no connection to this jurisdiction. Notably, however, in 412, the judge expressly did not take into account the value of the judgment in other contracting states in this assessment of useful purpose. Then he says, so finally, I was referred to the judgment of Mr. Justice Cochrane in Deutsche Bank. In that case, the judge granted declaration, including negative declarations, relating to the effect of a 2002 ISDA master agreement, an associated trade document, which was expressly subject to English law and had a non-exclusive English jurisdiction clause. The purpose of the declaration was then to be used in the courts in China. Mr. Justice Henry Carr's judgment in Fujifilm was cited to the judge. However, Mr. Justice Cochrane was not concerned about forum shopping given the choice of law and jurisdiction clauses. Taking stock, in my judgment, the position is the following. Roche's first submission, set out in paragraph 64.1 above, is wrong because it purports to place a limit on the court's power to grant a declaration even when it would serve a useful purpose. It's not right because the only relevant limitation is concerned with useful purpose. We agree. And then dropping down, he says, as for Roche's second submission, the first of it is wrong for the same reasons as the first submission. The second part of the submission is that the useful purpose test must be related to purpose that is useful in the context of a UK legal dispute. Deutsche Bank case shows why that is not correct. At least as long as one is not concerned with forum shopping, the fact that the purpose is useful in relation to a dispute in a foreign court may justify granting a declaration. On the other hand, Deutsche Bank is a long way from the facts of this present case because the foreign law court was going to have to decide the issue arising under the contract governed by English law. And then Roche's third point is not really a submission of law principle. True principle, in my judgment, is then considering all the circumstances and the issue of useful purpose, but we wish to identify what the real purpose of the declaration is. There may be more than one purpose. If we look carefully at a case in which only the predominant purpose of the declaration is sought to use the court's judgment in foreign jurisdictions. So, no hard-edged, look carefully at it, but no hard-edged position that you don't take it into account because it's used overseas. And then he turns to Belgian law at 93, and as Roche submitted, this is right at the bottom, 2 lines down from the bottom. As Roche submitted, as a matter of Belgian law, once it was granted, Pfizer could have commenced a national revocation action in Belgium to revoke the Belgian designation. So it was common ground that subject to a stay of the EPO, the earliest this could typically be done is 3 months after grant of local rules. Although there was some confusion in detail, by closing it was clear that such a claim could be completed at first instance by the end of 2018, but could well take longer. Now, Mr. Justice Burst declined the declaration in this case. We see that at 119. There is uncertainty related to the UK market that derives from the fact that the goods are to be supplied from a separate jurisdiction, Belgium, in which the uncertainty remains. And Pfizer really wants is a UK judgment so as to use it in Belgium. In Deutsche Bank, the issue was to come before the foreign court about a UK contract and UK law, so the UK court was naturally in a better position than the foreign court to rule on such a point. However, the position is different because the issue will come before the Belgian court. So different to this case, the fact that the Belgian court would take a judgment of this court into account does not alter the fact that the UK courts are in no better position to rule on the points of patent law. So what weighed in the judge's mind was the alternative of being able to go to the Belgian court. And it's at 122 are his conclusions. He wasn't persuaded on the facts of this case, but one needs to just keep in mind that, of course, this was just going back to paragraph 2, just so that one understands the timing. So the supplementary protection certificate was going to continue until June 2020. Pfizer wanted to launch immediately after that, so it was going to launch after June 2020. This hearing was being heard in April 2019, and there was an opportunity to have this all determined by the Belgian court. And of course, we're not in that, we're in a different position in this case, because the got a claim for a preliminary injunction in Germany with no opportunity to have the validity of the patent determined in Germany before that.
Do you say that this decision of Mr. Justice Burse was rightly decided but distinguishable, or wrongly decided?
No, we said, well, I mean, he set out the law correctly, and he applied his discretion. We make no criticism of that.
One of the matters he seems to have taken into account, paragraph 120, is that there is nothing to do with any UK legal right. It's only about what will happen in Belgium.
Yes.
And at paragraph 119, the issue which will become before the Belgian court will be about a Belgian patent and Belgian law. UK courts are in no better position to rule on those points.
Yes. That does.
Why does that not apply to the issue that will come before a German court, is whether an injunction should be granted in Germany on the basis of a German
Yes, so
patent?
So the application for a preliminary injunction takes place on the 15th of December in Germany. And the German court doesn't take into account, or is unable to take into account, aspects of validity, because it doesn't hear technical evidence. So, unlike in this case, where the Belgian court, you could have had a Belgian trial before the Belgian court can fully assess the matter. The German court isn't in a position. So we would wish to put before the German court, and indeed also country A, which a technical decision, a judgment based on expert evidence, which the German court won't have available to it and can't have available to it. So the caveat that Mr. Justice Burse is saying, well, it's in a position, the Belgian court is in a position to rule on that, doesn't apply. The German court will not have the opportunity to rule on the technical evidence.
The German court will only be concerned with the German patent.
The German court, they're the same patent. The patents are the same. So the UK patent and the German patent, they're all same claims, same document. And the courts are interested in each other's judgments. That's what Mr. Justice Arnold, Izzy Wormholz was pointing at. And the courts in Germany are obliged to take into account decisions of the UK courts. So that's why everyone here is getting hot under the collar arguing about this, because this really matters. This really matters, because my learned friend is going to be going to the German court saying, right, and to country A, saying, right, we must shut down this product, and you've got no materials in front of you other than a decision of the European Patent Office, so you have to assume the patent is valid. And we want to say, actually, that's not the position, because in the UK they looked at technical expert reports, said the subject matter was obvious. And that is, as we'll see when we get to the judgment of the ladyship, that was a matter, that's why these patents are being shielded, that's why we're all here spending a great deal of money arguing about this point, because it really matters and it will potentially make an important difference. My lords, finally, I think I wanted to go to two other cases briefly. One was, we've got a citation from Mexichem in our, it's in our skeleton, which is at tab 6. Here's another decision of Lord Justice Floyd, and it's paragraph 13. And just pointing out that it's a broad and flexible discretion to grant declaratory relief, paragraph 13. And then I wanted to go just briefly to ex parte ICI, which I think is at tab 16, I'm grateful. And it's just again a general statement of Lord Oliver, which is in a different context. But this is just this was a case about how profits on certain gas supplies were taxed and whether they amounted to state aid, because they were too favourable in the way that intergroup sales of ethane were assessed. And it was held that the revenue had adopted a valuation which was unreasonably low under the domestic legislation. And an issue on appeal was that the judge declined to grant a declaration, the effect of which would be to nullify the valuation which had taken place. But the judge made a prospective declaration going forward. And that was the point which arose on the Court of Appeal. And I just wanted to, the background, if my lords wanted to delve into the background, is best seen from 39 to 48. And the reason why the learned judge limited the relief is summarised at 111. But I was just going to go to 112. Where the judge said, this is Lord Oliver in the Court of Appeal. It says, I'm of course very conscious that we're dealing here with a discretionary jurisdiction in which this court must be very chary of interfering with the exercise of its discretion by the judge of first instance, lest he detect some error of principle. At the same time, it does seem to me that it must be wrong in principle when a litigant has succeeded in making good his case and done nothing to disentitle himself to relief, to deny him any remedy, unless, at any rate, there are extremely strong reasons in public policy for doing so. And we say if these proceedings are properly constituted, and we have won at trial, the court should be slow to deprive my clients, I mean, so close to trial. In fact, we're hearing relief before the trial, to deprive Teva of the potential benefits. Benefits which are very real, which is why we're all here. So, my lords, can I just summarise what we say the principles of law are? First, discretion to grant declaratory relief is broad. Second, in determining whether to exercise that discretion, the court should consider whether there is a useful purpose. That is not a high threshold, that is a useful purpose, and to be distinguished from abstract and academic questions. And then, if there is a useful purpose, then you can go on and consider special reasons under the guidance of Ms. Justice Newberg, or the reference by Ms. Justice Newberg. There is no rule, no hard-edged rule, that the useful purpose must relate to the United Kingdom. Fourth, in any case, questions of proportionality may arise. Proceedings may be stayed as an abuse because they are not worth a candle and therefore not proportionate. And that, we say, would bite on the Romanian example given. Forum shopping example. Or it may be, issues of forum may be a special reason. That seems to be what Mr. Justice Burst was doing in his decision. He was saying, well, look, the Belgian court is just as well placed as we are to decide this case. And as a matter of discretion, not as a rule of law, but as a matter of discretion, that was a factor in Pfizer. That's to be distinguished by Mr. Justice Henry Carr in Fujifilm, who said that it was something in favour where UK supply chains were to be impacted. And fifth, picking up the words of Lord Oliver, the court should not deprive an applicant of the declaration where it has made out its case, unless there are extremely strong reasons for doing so. And this part of the trial is taking place on the assumption we have made out our technical case. So we say claiming the declaration will serve a useful purpose. That's why Pfizer is so energetic in its opposition to it. And its energy evidences its concern that a judgment of this court will have an impact. We infer that it is concerned that it would reduce prospects of a preliminary injunction in Germany. And my lords have picked up the point in response to my Lord Justice Nugee's question. The German court won't otherwise have technical evidence. And it will be also serve a useful purpose because an injunction in country A will interrupt supplies of the product in the UK, a matter which Justice Henry Carr took into account. But we also emphasise, and we do rely on it, and I think Lord Justice Floyd put it to me as we would put it, one doesn't ignore what has gone on in these proceedings altogether. And this case is to be distinguished from Fujifilm, where a declaration was given, and Pfizer, where it wasn't, distinguished from both those, that we have been sued here. Interim injunction was sought here, was partially obtained, representations were made here to the court that the application would grant here. And therefore, it should not be open to Pfizer to say that this is not an appropriate forum. Indeed, we go further and we say that this is a special reason, a financial services law special reason, why a declaration should be granted in this case, even if it would not be in other situations. So, my lords, I was then going to turn to the judgment of the learned judge below, and I think that's tab 9, or bundle. So I want to pick it up first at 25. And again, we see that this is where the error has slipped in. And in our submission, it sort of comes from Mr. Justice Henry Carr expanding the comment by the Court of Appeal with respect to Romania. And she says the court should only be, it's 25-1, court should only be concerned with whether the declaration sought will serve a useful purpose in the UK. A declaration which is sought solely for the benefit of foreign courts will rarely be justified. And my lords had our submissions on that. We say that's not an established principle. And then 5, she correctly picks up, this is still in Fujifilm, the declarations serve a useful purpose in protecting FKB's supply chain to the UK market. That's a reference to FKB, where despite the UK being patent-free, the rest of the EU remains subject to the threat of potential patent litigation. She then refers to Pfizer and Hoffman and Roche, and she correctly summarises the judgment at 29, make no criticism of that. And then going on to 40, says, thirdly, as in the Fujifilm and Pfizer cases, Novartis has declined to provide any explanation of why it withdrew its UK patent designation after these proceedings commenced, but before trial. As in both those cases, I infer that the motive for doing so was to shield the portfolio from the risk of an adverse decision. It's the finding of shielding. And at 41, there is no doubt, therefore, that Novartis does have a commercial motive in resisting the declaration sought by Teva. That does not, however, mean that the declaration should inevitably be granted. Rather, it's necessary to consider Teva's specific reasons in support of the declaration to which I now turn. Just going back to the first sentence, no doubt therefore that Novartis does have a commercial motive in resisting the declaration sought by Teva, as we say that that is useful purpose. And then she goes through the deals first of all with conduct. She says Teva's first reason turns on Novartis' conduct, particularly the fact that Novartis initially sought to enforce its patent in the UK to the point of seeking interim injunctive relief before ultimately abandoning the UK designation only months before trial. And then there's a discussion whether that was a self-standing thing, which I think the judge says I didn't maintain, which is correct. And then at the end of 43 says Novartis' conduct therefore falls to be considered as part of the other factors relied upon by Teva. And I just wanted to go to the pleading amendment, just how we put it. So that's in the core bundle at tab 12, same bundle, tab 12. We pleaded as Teva also places reliance upon the special reason. Page 83 of the bundle.
Thank you.
Sorry. Teva also places reliance upon the special reason that Novartis has aggressively pursued patent infringement proceedings against Teva and other defendants. And then reading through tactical advantage. And then towards the end of that paragraph, we are having commenced infringement proceedings in the UK in relation to 894, having sought for a limited time obtained interim injunctive relief, submitted that Novartis should not be permitted to avoid declaratory relief and obtain a procedural advantage in this way. So that was being put forward as a special reason in the financial services and rules sense. So going back to the judgment, just at the end of 43 says, therefore, falls to be considered as part of the other factors relied upon by Teva. We'll come back to that. She then deals with the NHS, which we're no longer concerned with. And then I think we can pick it up to she assesses the German evidence at 56 through to 59. We make no criticism of that. I showed my Lord's the basis of that. And then it's at 61. There's more importantly, however, when the nuance of the views of the experts on this point, the fundamental problem with this aspect of Teva's case is that the case law discussed above consistently establishes that if the only or predominant purpose of the declaration sought is to use the judgment for a foreign court, the court will look carefully at the justification for the declaration. In such a case, the declaration is only to be granted in an unusual case or a very compelling justification for doing so. So we say this is, and we see it in a later, comes back in a later paragraph. This is a principle she's applying, that you don't just ask about useful purpose. You have to look for a compelling justification. And we say that has not been established in the case law. And certainly is not consistent with the approach taken by Mr. Justice Burse in Pfizer. And we say she's fallen into error, has not done what she should have done, which is to exercise her discretion within the broad context provided. She should have, we submit, first of all asked, was there a useful purpose? And then she should not have dismissed a useful purpose if it was the circumstances that we're concerned with here. She'd essentially identified that useful purpose back at paragraph 40 or 41. And then we'll see how she continues. So useful purpose never really, that's it. And then we're on to supply chain. So she then says, Teva's answer to this is the supply chain to which I now turn. So my understanding is, may be right, may be wrong, but she's now moving on to compelling justification. So she says, it's only be granted if there's a compelling justification. So this is Teva answer to there being a compelling justification. And then there's a reference to supply chain, and we say this should have been part of the useful purpose analysis. Teva says the effect of the declaration would be felt in the UK because of Teva's supply chain to the UK involves transit through country A, which is injuncted in that country. Teva says it would be time-consuming and expensive to alter its supply chain. Teva will therefore seek to rely on any declaration of this court in resisting any injunction in country A. And then she dismisses effectively some of the arguments of Novartis. So at 66, she says Novartis' second criticism was that Teva's evidence of supply chain disruption was very weak. And then I think we can drop down to 73 VAT. Whereas then, in that regard, a key difference between this case and Fujifilm. Fujifilm, as I explained above, the central plank of the decision of Mr. Justice Henry Carr was the impact of the declaration dispelling uncertainty in the UK market. Correct, that was an aspect, but equally well, supply chain disruption was clearly weighed in the judge's consideration. In the present case, I've already found that there's no evidence of such uncertainty. That was essentially the position of Pfizer. Mr. Justice first refused to grant the declaration sought on the basis of predominant purpose use in the Belgian court. Dr. Turner sought to distinguish the facts of Pfizer on the basis that in this case, Pfizer's product had not launched and appeared on the evidence the first instance proceedings in Belgium could be completed by the time that Pfizer wished to launch its product. And then she says it is, however, difficult to see what difference that makes. The point of principle, so she's applying a point of principle. The point of principle in both Pfizer and the present case is that the purpose of the declaration was and is to influence a foreign court whose decision is likely to impact upon the supply of product to the UK, whether or not that supply has already commenced at the time the declaration is sought. So this is a. So even with the supply point, she's saying there's a point of principle here that our interpretation is that you can't rely on that at all, or for the purpose of useful purpose. It's a point of principle. We say she should not have applied that. And looking at 76, then comes on to. The question I therefore would ask is whether there are particularly unusual circumstances in the present case which provide a compelling justification for the grant of injunction sought by Teva. In my judgment, there are not. As I've already noted, there is nothing unusual in the fact of global supply chain. As a result, the decision in one country may impact on the supply of product to another, specifically in the UK. Nor in my judgment does Novartis' conduct in this case tip the balance in favour of granting an injunction in the present case in circumstances where, as I found, unlike Fujifilm, it cannot be said that the conduct has resulted in any continuing uncertainty. So we don't, our submission, the learned judge hasn't done what she should have done, which is first look at useful purpose and not excluded useful purpose for purpose of, say, Germany. She seems to have excluded that, but she should have said that is a useful purpose, and then gone on to special reasons. And she hasn't, she sort of just dismissed the special reasons of what has gone on in the past without explaining why. But the analysis is not structured, we think is the problem, because the learned judge had in mind this point of principle she refers to in 75. And then she says Dr. Turner has not identified any factors which justify the grant of an narrow declaration. So she's starting off from a presumption against a declaration because it's for use in Germany or country A. So it starts with a presumption against and then looks for a compelling justification to sort of reverse that presumption. We say that's the wrong approach. My Lord, standing back, we submit that it's extremely unsatisfactory that an injunction was sought on the assurance that the application would be granted and without explanation after service of evidence fact it was was practically abandoned and no explanation given. I don't think even my learned friend is going to stand up and commend his client's conduct in this case in that regard. There is no mischief in granting a declaration sought in this case. Why would the court not grant a declaration, I ask rhetorically? If we are right that the technical subject matter is obvious, and that evidence has been served, and we're at the point of a very short trial, what is the reason for not granting a declaration? It's not a hypothetical issue. I cannot say it's not a real issue between the parties. It very much is. Of course, Novartis do not want you to grant the declaration because it may reduce the chances of getting a preliminary injunction on an invalid dosing regimen patent in Germany. But there's no merit in that position. So if we are right that there is no established principle of law that the court should not have regard to a useful purpose in another contracting state, as Mr. Justice Bursars held, there's no virtue we see in introducing for the first time that principle in our submission. And we are, of course, entering a new phase of European patent law with the introduction of the UPC shortly, and we do not know what jurisdictional games will be played in the future on this new pitch and how this court will fit into those jurisdictional games. Our declarations may well have a role to play in the new system, and the court should not preclude that in our submission by making the sort of or endorsing the sort of principle that the learned judge did in this case. As we say, the learned judge should have exercised her discretion more broadly. She should have asked, is there a useful purpose? Answer, yes. Position in Germany, supply chains through to the UK, etc. Then she should have considered special reasons, and had she done so, at the forefront of the mind would be Novartis has been sued in this country on the standing there was a UK patent. I'm conscious I'm repeating myself. And we submit, had she taken that approach, declaration would have been granted. My Lord, lastly, very last point, there is in the authorities bundle, my learned friend has put in an Italian decision, recent Italian decision, which is not in there as a point for a principle of law. It seems to be in there as a dispute of fact, or not a dispute, as a new fact to introduce into the mix. It wasn't before the learned judge. There's been no application to introduce it, so my lords, I want to put a marker down that we don't accept that's admissible. I'll be my learned friend to deal with that. Can I just take instructions? See if there's anything. Unless I can help.
Thank you.
Well, Lords, I will come to the Milan decision in due course, but just to explain, both solicitors, before the learned judge, expressed what was going on around Europe generally, and included Germany, France, Holland, Spain, everywhere. The judgment was dated 25th of October, which post-dated the judgment by about a week. So I'm afraid if had we had it, it would have been included in the evidence, but we couldn't have provided it sooner. So I'll come to that for the relevance of what it has in due course. Roger, our respectful submission, the learned judge properly exercised her discretion to decline to allow the matter to go forward for a technical trial and not to grant the declaration sought. We are in a slightly odd position that my learned friend keeps commending how very short it will be, possibly done on the papers, because it's not going to be opposed. There won't be cross-examination. And it will therefore be extremely superficial. It won't actually get into the issues. And the other foreign courts will see that. There's a decision of Mr. Justice Mead where he says, well, what's the purpose of producing a half-baked decision when, in fact, the arguments haven't been trammelled at all? And I'll come back to that in due course. Now, Ros, being a matter of discretion, it's very well established that the court will only interfere if the judge has exceeded the generous ambit within which reasonable disagreement is possible. There has to be an exercise of discretion upon a wrong principle, to use Lord Fraser's words in G&G. Now, my learned friend has said that paragraph 61, which is the high watermark of his case, represents an error of principle where the court should be very cautious about producing a judgment for solely or the predominant purpose is for use overseas. And I'll be making good that that was an entirely correct summation of the state of the law in due course. One of the cases that my friend cited lastly was the case of the Queen against Attorney General against ICI. It doesn't assist my learned friend, because what happened in that case, he summarised the facts after extensive argument involving some of the leading silks of the day. ICI won the substantive issue that the Inland Revenue's approach to the taxation of certain petrochemical products was not in accordance with the relevant statute. ICI also won the argument that they could challenge that. They had locus standi, even though the assessment was as regards, I think it was BP or Shell, and therefore they didn't have locus standi. They also won that argument, but there was a second hearing before Mr. Justice Wolfe, as he then was, whereby it was a declaration was given that did not give effect to that outcome. Basically, ICI would have been at a disadvantage for a further 15 years, even though they had won the trial, having been heavily contested. And the remarks have to be seen in that context. And it's paragraph 110 at the end that actually gives the full context of that comment. Can I just ask the court to turn up JA tab 15?
You were right first time.
I was right first time, sorry. And it's really at, one sees, for example, at page 100, it's page 442, '44, 45 and 46. 45 was the points that failed to be considered, on which ICI won. And then 46, what's principally given rise to ICI's complaint over the second judgment delivered by Justice Wolfe on 3rd of April, in which he dealt with relief to be granted consequential upon the substantive decision at which he'd arrived. It was ICI's contention the appropriate remedy was a declaration which, on the assumption the revenue had accepted an election on Mr. Cooper's evidence, it would have had effect of nullifying that acceptance. He declined to make such a declaration. And 48 at the bottom of 442, as Mr. Alexander has pointed out, this effectively deprived ICI of the fruits of litigation, since, as they suspect, elections have already been made and accepted on the basis found by the judge to be wrong. It's capable of continuing to operate for the next 15 years. And then if the court would go to page 100, page 459, we see where, in fact, they win, both under national law and under European law, that they had locus standi. That's 103, they had locus standi under European law. 107 to 110, they had locus standi under UK law. And 110, which my little friend hasn't sidelined, that brings me to what is, from ICI's point of view, the critical issue and the principal reason for instituting and pursuing this appeal, namely the question of the appropriate relief. I've already set out in terms the only declaration the learned judge was prepared to grant, one directed to particular approaches which the remedy should not adopt on any future election, but which leaves entirely untouched the question of whether, on the assumption an election had already been made and accepted by the revenue, it was found to be a wrong principle, and acceptance was, and is, as Mr. Alexander comes, ultra vires and void. If that be the case, there's been an election which has already been accepted, and I'm bound to say it seems to be almost inevitably, since Mossamorgan is going on stream, the effect is that, subject to cataclysmic changes as are envisaged, the election formula will constitute the basis of the oil companies' PRT assessments and thus affect their competitive position for the next 15 years. Thus, effectively, ICI is being deprived of any useful result from litigation which, on any primary matter in issue, they succeeded. That seems to be an odd result, and one which seems to me, at any rate, is difficult to justify as being fair or reasonable. So they'd had their trials, they'd gone through everything that they had to go through to challenge the decision, and yet they were not given the declaration that they were seeking. That's the context of the comments that were made there. And in our respectful submission, they have no resemblance to the issues with which this court is concerned. And the fundamental question before the court is whether the UK court should allow arrow declaration claims to be made where the sole or predominant purpose is not for the resolution of any right or uncertainty in the United Kingdom, but purely for export to other jurisdictions in the hope that they will be of some influence there. Now, I was reminded of a hearing that I did in the Court of Appeal before Lord Justice Alder sitting in the chair, 2 judges. It was in Amgen and Roche and TKT, 2 of the largest biopharmaceutical companies. And one of the judges, I think it was to the left of Lord Justice Alder, said, Mr. Wall, why are we devoting our resources to what is fundamentally a commercial question between your clients? Now, of course, it was a UK patent, and that was the answer, that the court exercises a supervisory jurisdiction over a UK patent. But what Teva are asking the court is not to resolve any UK position about patent rights at all. What Teva are asking this court to do is to generate effectively an advisory opinion in order to assist the German court and therefore help Teva's commercial position in Germany. And I'll be coming to some observations of Mr. Justice Voss, as he then was, and also to some extent Mr. Justice Mead, that says that is not an appropriate use of the UK's resources. There are enough things to be getting on with without giving Teva a leg up in Germany, possibly, should the German court show an interest in a judgment from this court. And I have to correct one thing immediately. My little friend's given an indication or said that the German court doesn't receive technical evidence on a PI. It does. It hears an extensive amount of evidence, and I'm going to come to show the court the Takeda decision, where basically Mr. Justice Bers was urged strongly to revoke a patent, which he did, in time for it to be taken into account by the Düsseldorf infringement court. And basically the Düsseldorf court said, well, we obviously do things slightly differently, and they looked at the technical evidence and they formed a different technical view. And in this case, Teva have actually put in technical evidence from a clinical clinician. So I don't know on what basis Mr. Turner is saying that they don't receive technical evidence on a PI. They certainly do. They sit slightly differently. They regard themselves as technically qualified, as many members of this court are. And it's not to say they don't receive technical argument extensively and they don't receive technical evidence. They do. And I'll come back to that, if I may.
So just get it clear in my own mind. Are you saying that a declaration in these circumstances does not serve a useful purpose? Or are you saying that the useful purpose that it does serve is not a legitimate one, or do you rely on the special reasons? Do you say that although there's a useful purpose, there are special reasons?
Well, I say there are no special reasons. Well,
special reasons why the court should
no,
not.
I'm saying there are no special reasons why the declaration should be granted. And I'm saying very much in terms that this is not a sufficient useful purpose. As Mr. Justice Bers found...
You're imposing a threshold on the useful purpose, which is not met by a declaration in support of foreign proceedings.
Yes, and Mr. Justice Bers in Pfizer and Roche very much found in the paragraphs before the passages my own friend read that there was a valid use commercial purpose, that there was a commercial purpose behind what Pfizer was seeking in that case. But it's not the useful purpose in law. So I say it's not a useful purpose. It has to be in support of a UK legal right or UK dispute.
But it sounds as if you don't say that it amounts to a special reason for not granting the declaration.
I do say that even if my little friend was to show that it was a sufficient useful purpose, I say that in terms of the overriding objective, it's not something this court should be doing as a matter of resource management.
Well, that does sound like a reason why the court should not grant it.
Oh, it is a special reason not to grant it.
Okay.
Sorry, cross purposes.
Okay, so if it either doesn't meet the threshold for a useful purpose, or alternatively, there's a special reason, namely the use for foreign proceedings, which is a reason for not granting the declaration.
Yes.
I think you do accept that it would be commercially useful to Teva to put before a German court if it could be done. But you say that doesn't qualify as a useful purpose within the meaning of our jurisprudence.
Correct. And that's very much the case with Pfizer and Roche. We'll see what the commercial purposes were, but it wasn't a useful purpose so far as the grant of a declaration was concerned. Let me come back to that. When these proceedings were commenced, they were commenced by Teva. They were launched by Teva because, as the court is aware, the patent there was a hearing before the TBA in February, at which hearing they said this patent will grant. And the patent, the decisions didn't come out for months. And the actual grant of the patent didn't emerge for months, even though at that point it was clear that it would emerge, subject to de-designation. And therefore it was Teva who brought these proceedings in order to raise their grant of an arrow declaration, invoking purely United Kingdom reasons. At that point, there was no suggestion by them that they were wanting to export it. And we see that from their particulars of claim dated the 25th of February, which are in the core bundle, tab 12, page 81, paragraphs 18 to 20. Now, the grounds which were relied upon before the judge were those that were added by paragraph 23A, which the court has already seen in green, which were allowed in September after we had said that we would not be designated in the United Kingdom. So this was, in a sense, why the European dimension was brought in for the first time. And as the judge recounts, even though other defendants had brought UK claims for declaratory relief, the claims have been settled in principle against all the other active defendants. And to answer my Lord Justice Nugee's question about the cross-undertaking, yes, extensive payments being made out on the cross-undertakings, costs are being met on a generous basis. So it's not as if this does not come at a cost to Novartis. Novartis are paying the consequences of having some interim relief as a consequence of the undertakings granted until it was finally resolved that there would be no PI, no interim injunction. And that's significant because if my little friend were right, in many cases, let's assume the patent has been granted, has been asserted. One could say, well, you're locked into litigation now. You asked for this. Now you've asked for it, whether it's by a writ or whether it's a pending application or whether it's a granted patent. Fred, you can't back out without an arrow declaration because we'd like to export this elsewhere. We accept there is no UK dimension anymore, but nevertheless, we would like the value of what we can get elsewhere. That would make it extremely difficult to actually back out of litigation. My own friend, Dr. Turner, said, well, what might happen is, in those circumstances, you'd get a decision against you. Well, and he cited Arnold. Well, the general rule, as we will see in another case coming in a minute, that's not the general rule. Arnold was exceptional in as much as the patentee wrote a letter on the Sunday evening before the Monday was called on for trial, saying that they didn't think they were going to get a fair trial. They didn't think that they had time properly to prepare, and therefore they were abandoning the patent. And Mr. Justice Laddie basically said, not so fast. I've read the papers, he'd read them over the weekend, and I formed the view that this patent is invalid, and therefore I'm going to so declare, and I'm going to make you pay indemnity costs as well. And that gave rise to the Connaught line of authority on what was then RSC Part 24, about whether her judge had read or considered papers in open court. Because the judge said, I have read these papers in open court because they were on the skeleton argument, and I have formed a very clear view on the basis of those papers. And that's authority that this court may be aware of. So that's a very special case of Connaught, but it doesn't apply at this stage of litigation. where there hasn't been a resolution of the issues. And I'll come back to that in a minute if I may. Now, once the decision was made not to designate the United Kingdom in this patent, it was only Teva who applied to widen up the claim in the way that they had. Viatris or Mylan are also defendants, or a number of other defendants. However, we are where we are, and we're now in a position where, on the judge's unchallenged findings, there is no uncertainty in the UK of any nature. My learned friend started by rattling through the idea of these divisionals. It's not challenged that there's no uncertainty regarding the undertaking that's been given under the divisionals. So that was all a colourful background, but actually has no significance to the issue this court has to make. The unchallenged finding of Mrs. Justice Bacon is no more than a UK judgment will be of some interest to the German court. And for reasons explained in the cases, and as a matter of policy, that is not a sufficient purpose for arrow relief. It is asking the court for the resources of the UK court to be deployed not to resolve a legal right in this jurisdiction, but to enhance its position in other jurisdictions where the patent has been designated. That is forum shopping, pure and simple. It's not what the resources of the UK should be devoted for, and we'll see what Mr. Justice Voss had to say about that in the Drexelmeier case in a minute. And before I do that, the first thing I would stress is that this is not a spin-off case, as spin-off is properly understood. Where there is a UK-centric issue, such as the validity of a UK patent being litigated, it's possible to think in terms of there being spin-off from a centre of gravity in the United Kingdom. The courts have held, as in the TNS case, which we'll look at, that it's not necessarily abusive conduct to rely upon what's being spun off from the UK proceedings, but where there is good reason to have the UK proceedings in the first place. The very term spin-off has its roots in the consequence of something spinning around a core and sending material outwards, akin to a Catherine wheel. But where there is no UK substance to the dispute, and the sole purpose of the dispute is for export, it no longer makes any sense to talk about spin-off. Rather, it is the procurement or generation of a judgment for export, where that is its sole raison d'etre. Now, if I can just deal with the Arrow case law first. The court will have read what we've said about Fujifilm, both in the Court of Appeal and before Mr. Justice Henry Carr. And it is important to bear in mind that those cases contend are in respect of UK-centric issues. In Fujifilm, the consistent aspect of the judgment, and which underpinned the granting of the declaration, was the uncertainty in the United Kingdom with respect to putative patent rights, which were caused by AbbVie's deliberate conduct of engendering such uncertainty in the UK, generally by Mr. Rick Gonzalez of AbbVie issuing these blanket threats from America. It was worldwide saber-rattling, which was intended to include the United Kingdom. And we give the references in paragraph 14 of our skeleton, and I won't go to them now. But can I pick up a paragraph 369 in the judgment at JA, it's tab 1, and it's page 89. And just after, I just want to pick up bits that my learned friend didn't refer to. My learned friend referred to 367. But I think 368, it's also important to note that it's well established that the attainment of commercial certainty in patent cases can be a useful purpose. And it may be in the interest of justice to grant a declaration to dispel commercial uncertainty, emphasised by Mr. Justice Kitchen. In Arrow declarations, there is public interest in commercial certainty in pertinent matters as in any other. Business needs to know where it stands. I believe this court should assist in providing that certainty where it properly can. So an emphasis, the genesis of Arrow was Mr. Justice Kitchen's judgment in the Arrow case, and that was its raison d'etre. At the end of the passage from my Lord Justice Floyd at 369, at the end of paragraph 8, in IPCOM, and this was a stay case, halfway down 8, it's true that it won't be possible to attain certainty everywhere until the EPO's final result, but some certainties are unsuitable and somewhere, such as in the UK, rather than nowhere, is generally preferable to continuing uncertainty everywhere. So the emphasis was there in obtaining certainty in the United Kingdom. And I'd like to look at what my Lord Justice Arnold said about stays in the context of TNS in a minute, because it's to the same matter. Then at 370, the learned judge turns to the FK appeal judgment, also given by Lord Justice Floyd. At the end of 371, I'd pick it up. The last 5 lines, those findings would have gone a long way to establishing its freedom to operate before launch. Because of the way AbbVie have appeared to act, there is a case for the court to intervene by way of declaration to provide FKB with a measure of useful commercial certainty. And then we get to the question of spin-off value of judgments. And reliance was placed on TNS and Nielsen, which I'll look at in a little more detail. So TNS and Nielsen was cited to the judge on the question of value of spin-off, and that was the prelude or the lead-in to what he said in 374, and accepting that spin-off can be very valuable, legitimate, however important not to extend the principle too far. Statements as to spin-off value have been made in the context of applications to stay pending resolution or applications to expedite. Those cases are very different from the present. It's also important to guard against forum shopping, where a declaration from the UK court is sought in cases that have no connection with this jurisdiction. And that, we say, is an entirely correct statement of the law, and I would commend it. And then, respectfully commend, I should say, then we have 375, where the Jamil judgment was set out. And I would submit this in answer to the question from the bench by Dr. Turner, to what legal principles the judge is later referring to. I would submit he actually he's going right the way back to page 88, where he starts on legal principles, discretion to grant declaration, and at least including spin-off value from 372. So he's having regard to Jamil when he says what he says. And then I would say 377 is not in error. This, amongst other, this is at page 92, this among other authorities relied on AbbVie shows that when considering whether to grant the declaration in the present case, I am concerned with whether it will serve a useful purpose in the United Kingdom. A declaration which is sought solely for the benefit will rarely be justified, as an emphasis by Lord Justice Floyd in the FK appeal judgment. In my respectful submission, he is saying will rarely be justified if it is not a useful purpose in the United Kingdom. As Mr. Justice Burse acknowledges later in Pfizer and Roche, there is no hard-edged principle. Never say never, but that is a correct circumspection to exercise, with reference to my Lord Justice Floyd's judgment of paragraph 95 in the Fujifilm appeal. So, as a consequence of what he had said in those paragraphs, at 411 to 412, which is at page 99, this is where he turned to the question of spin-off. Submission was made to him there be influential in other European courts and tribunals, make it more difficult for AbbVie to obtain PIs, particularly in jurisdictions where validity cannot be challenged. So it was precisely the same argument in 411 that this would be useful to assist in resisting a PI. And yet he says he accepts it's valuable, can be legitimate, but on reflection, having regard to legal principles, I have not taken this into account, other than the extent to which this may have an impact on the UK market. And in that respect, a very point of distinction on the facts is that the claimants, Fujifilm and Biogen, were putative biosimilar. They didn't actually have a marketable product at that stage. They had not at this stage set up their supply chain into the United Kingdom. And the evidence was that it would be difficult to set up the supply chain, and that would have an impact in the United Kingdom. But in terms of the value to influencing Germany, that wasn't enough. Now, in our submission, clearly the next case of significance is Pfizer and Roche at tab 2. And Roche, in this case, despite having a valuable monopoly in the UK, took the voluntary step to abandon its UK protection in the UK, together with the prospect of obtaining any protection in the future. Pfizer ran the similar arguments that the Arrow Declaration was justified for the following reasons. First, the Pfizer supply chain relied on free passage through Belgium. Second, a patents court judgment would be taken into account by the Belgian Patents Court, and therefore a patents court judgment had both overseas value and could help prevent disruption to Pfizer's supply chain. The facts, so far as their material, are indistinguishable from our case, and I'll mention my learned friend's suggestion that timing was different. But despite those findings, that they were of value to Pfizer, Mr. Justice Burse, we say correctly, found that they were not sufficient to justify an Arrow Declaration, despite his finding of shielding at paragraph 111. He expressly made the finding in paragraph 111, where he says, I infer Roche's motive for de-designating the UK to shield its portfolio from the risk of an adverse decision of the court. There is no other rational explanation. But if I could just pick it up first at 117, because this is where Mr. Justice Burse, as he then was, starts off by analysing Messier-Doughty, also Rolls-Royce and the Union, and the FSA and Rourke criteria in paragraph 71, and he gives those careful consideration. And at paragraph 77, he analyses Nokia and Interdigital, Inri, Clay and Marlbush, and he says, at 78, of course, subject to a possible exception below, the cases on Arrow jurisdiction itself have all been concerned with the existence of the scope of a legal right in just the same way as previous cases. The disputes to be resolved about the existence of the Gillette defence, which may lead to an Arrow declaration, may be purely matters of fact or mixed questions of fact and law or business. Well, what is being declared is that the holder of a certain patent company will have no legal right to run any patent arising from the preventive risk of sale of the product. The same is true of a declaration of essentiality, Nokia, and a Fran declaration on wire. The possible exception to this principle is the decision of Justice Henry Carr in Fujifilm. This judgment came after the Court of Appeal's decision cited above, which had been decided at an interim stage and held the claim should go to trial. And then he recites the submissions made in 80, but then picking it up at 81. So the circumstance that the patentee had claimed it had or would have certain legal rights in the UK generated sufficient commercial uncertainty about the nature and scope of legal rights that were damaging to the claimant, offering complicated and unclear undertakings, supposedly to clarify the situation, but it did anything but. In those circumstances, it's not hard to see why a court was prepared to exercise the declaratory jurisdiction. And he says, standing back from the details of the Arrow Declaration, of course, there is no general threshold jurisdictional requirement that the defendant must actually have some kind of legal right in the first place before the court's wide declaratory jurisdiction can be exercised. After all, the declaration can be one the defendant has no right at all. The point arising here and in Fujifilm is more nuanced than that. This court could readily grant a simple declaration that Roche has no right arising from a defined patent family into the United Kingdom of the relevant products. The reason that is true is because of the de-designation. That's not what Pfizer wants, nor it's what Roche is resisting. The declarations are all in substantially the same form, and then an Arrow declaration form is set out. And then the last half of that paragraph, the declaration sought is not merely that no UK rights exist, but brings the action and why that is so. The true purpose of this is the impact of such declarations and the reasoned judgment leading up to it in foreign jurisdictions. That is what Justice Henry Carr called spin-off value of the judgment. That's what the present dispute is really about. Justice Henry Carr dealt with this in paragraphs 372 to 377 and came back to it in 412. As the judges in those passages, I agree that the use of a UK patent judgment in other contracting states can be very valuable and it's legitimate for parties to rely upon the judgment in that way. However, the judge also said, and I also agree, this cannot be taken too far and one needs to take into account the risk of forum shopping. where a declaration is sought from a UK court in a case with no connection with the jurisdiction. Notably, however, in paragraph 412, the judge expressly did not take into account the value of the judgment and other contracting states in his assessment. He explains why Deutsche Bank is different, because it was an English law contract subject to English law, and he says that wasn't forum shopping. And he says in paragraph 87, the Deutsche Bank case shows why that submission is not correct, at least as long one is not concerned with forum shopping. The fact the purpose is useful in relation to a dispute in a foreign court may grant a declaration. However, Deutsche Bank's a long way from the facts of this case. And this third point is in 88. Roche's third point is not really a submission of law or principle. The true principle, in my judgment, is that in considering all the circumstances, the issue of useful purpose, the court will wish to identify what the real purpose of the declaration is. There may be more than one purpose. We'll look carefully at a case in which the only or predominant purpose of the declaration sought is to use the court's judgment in foreign jurisdictions. And we say that is, again, quite correct. And that is what the judge was saying in paragraph 61, that's alleged to be an error of principle, where she says the court should be very cautious.
Well, she goes a bit further than that, doesn't she? She says there has to be very unusual cases where a very compelling justification is made
Yes.
out to do so.
Well, that is discernible from both Pfizer and Fujifilm, where there was no such compelling reason to give the declaration, even though in both courts, before Mr. Justice Henry Carr and Mr. Justice Burrs, it was accepted that one would not, the Belgian court or the foreign courts would take the judgment into account. That was a given, but that's not enough. And it's not enough because of the consequences for forum shopping. Now, if one goes to paragraphs...
what would be an example of some very compelling circumstances which would make use in a foreign jurisdiction?
There would have to be no other essential way of properly vindicating your rights in that jurisdiction.
Right.
And it's hard to imagine that... certainly, these circumstances are not compelling. It's a bit of an elephant test, but there has to be an element of compulsion that makes it, even though there's no useful purpose, it really compels us to say we must do this anyway. Yes, or the other, my journey reminds me that as in the Deutsche Bank case, a compelling reason was that the UK court was actually much better placed to rule on UK law than the Chinese court, because we are English lawyers. If the court could go on in Pfizer and Roche to paragraph 110 onwards. 111 I've already mentioned, which was to shield the UK, was to shield the portfolio from risk of an adverse decision. That's 111 on page 129. He also finds, as another example of real commercial values, is that a judgment would be taken into account in Belgium, assuming it was favourable to Pfizer, could help resist a patent case brought by Roche in that country. So that was considered to be of value at 117. But then when we get to 118 to 122, when one reads 118 through to the end, the parallels in this case are such that you can substitute directly Teva for Pfizer, you can substitute fingolimod for bevacizumab, and you can substitute Novartis for Roche. And it would follow that if today there were pending applications, that would be a plain case for an arrow declaration, and the court would go on to examine the merits of the Gillette defences. However, given the complete absence of the possibility of UK rights in future, the reality is that the commercial value of an arrow declaration to Teva in this case is the utility it might have, along with a reasoned judgment, in helping Teva defend itself against suits brought by Novartis in other European countries. This case is unlike Fujifilm. In relation to fingolimod, there is no outstanding uncertainty at all in relation to UK rights. Teva doesn't need the patents court to tell it, or anyone else, it can freely sell fingolimod in this country without risk from Novartis patent family. He says there is uncertainty relating to the UK market, but that derives from the fact that the goods are to be supplied from a separate jurisdiction, in this case country A, in which the uncertainty remains. Now what Teva really wants is a UK judgment to use it in country A. In Deutsche Bank, the issue was, and that's summarised, that wasn't forum shopping. However, the position here is different because the issue which will come before country A, if it ever does, will be about country A patent and country A law. The fact that a country A court would take a judgment of this court into account does not alter the fact the UK courts are in no better position to rule on those points of patent law. It's true that under the EPC we apply the same law in Belgium and in the UK, but that's not a sufficient justification for embarking on the exercise of the technical issues. So, and after playing down settlement, which is always something of a make-weight, it wasn't sufficient in this case. He says, after it not being enough in 122, when the action began, it wasn't forum shopping at all. There were pending UK applications which provided a basis for considering an error declaration. However, they have gone. There might have been other factors which justified error relief, as those in Fujifilm, and that was, of course, uncertainty. But on examination of this case, there are not. There is no evidence of uncertainty about UK patent rights. The true purpose of an error declaration in this case would be for it to be used in foreign courts. Not persuaded that is enough. And we say it's not enough. And applying the same rationale on the basis that there's nothing that distinguishes this case from that. And I'll come to my own friend's grounds of appeal as to how threatening proceedings might make a difference, but it doesn't. Now, there was no challenge before the judge below, and we quote the interchange between the bench and Mr. Turner as to the correctness of the legal principles in Pfizer and Roche. So, to the extent that the court in Pfizer and Roche endorsed what Mr. Justice Henry Carr had said in Fujifilm, they are on the same page. There's no difference between them, and the acceptance of Pfizer and Roche as correctly stating the principles was explicitly made for the court below. Now, there's no difference in approach between Fujifilm and AbbVie. Fujifilm and AbbVie was manifestly an exceptional case on different facts, and I've mentioned the fact that it was a nascent product yet to come to the market. What AbbVie were doing was that they were actually manipulating the EPO by not getting patents, and they were basically not getting them for any jurisdiction. They were pulling them completely. So there was it was a case of generating uncertainty upon uncertainty. And also, importantly, Mr. Justice Henry Carr in the Fujifilm case rejected the submission that AbbVie had unequivocally abandoned UK protection for the future, because there was still the possibility that some divisionals would actually come out of the woodwork. That's paragraph 356 of the AbbVie judgment. So there were many reasons why it was right for Mr. Justice Henry Carr to do what he did after a 2-week hearing of the technical issues. Now, on the observations of TNS, I said I would come to this, and now is a good time, assuming it's time before the short adjournment, to look at TNS at tab 14 of the authorities bundle. And it was, as I said, a case observations made in the context of a strikeout application, and also a stay application made in the alternative for my Lord Justice Arnold, sitting in the courts below. And it was being said that because of certain steps, by granting a license, which I'll come to in a minute, it was said that the proceedings were basically pointless, and there was no point in going on to proceed to determine them, because it was an abuse of the process. Now, what the court will be familiar with, under Section 71 of the Patents Act, there is an underlying right given to any person, quotes, who wishes to revoke a patent. It used to be any person aggrieved could bring an action, and when the 77 Act came in, it could be any person could seek to revoke a UK patent. And where it sought to strike out any action as an abuse of process, it's a high bar to cross where someone is exercising that statutory right. And notably, in TNS, there were a number of reasons put forward for maintaining the action, of which spin-off was just one. And that's seen from paragraph 21 of my Lord's judgment at 390. It said, the second basis upon which the defendant contends the claim to revoke is an abuse of process is brought for an improper or collateral purpose in the sense described by Mr. Justice Pumphrey in Cairnstalls. The contention that the claim is brought for an improper or collateral purpose is based upon evidence given by Alan Johnson, a solicitor and former partner of Bristow's, a partner in the firm of Bristow's, who has the conduct of the action on part of the claimant. And he says this, finally on this topic, the choice of the UK has the obvious benefit that it clears the 860 patent out of the way in a country where the claimant is offering services which the defendant may allege come within the scope of the patent. So it was a UK-centric issue, first and foremost. There will then be a possibility of arguments as to the scope of the licence or the parties entitled to take the benefit from it, because it was being argued that although the patentee was offering this licence, its terms were said to be unclear, subject to debate, and of course it wanted to keep them confidential. Now 21, Mr. Johnson says this, I'd like to draw attention to three other issues which are important to the claimant. First, there's another motivation in bringing these proceedings. In view of the previous conduct of the defendant and AGB, the claimant is very concerned it may face similar tactics of threats of proceedings being used against customers in other jurisdictions based on the 860 patent. And he says at the end, I understand 860 is in force in three most significant countries referred to in the table, Netherlands, Germany, Denmark. Absent wide-ranging, the most effective way to demonstrate to customers, potential customers of UK-based companies, the worthlessness of the 860 patent is to have it revoked in the respective national jurisdictions of the UK. It may be exported to other courts and shown to customers and potential customers. Now, what was then said in paragraph 22 was counsel for the defendant submits that paragraph 22 of Mr. Johnson's witness statement, and in particular the word that the decision may be exported, demonstrates the claimant's true purpose of commencing these proceedings to obtain a judgment for use in other contracting states, and therefore an abusive process. In my judgment, what he says is not evidence of any improper or collateral purpose. Clear line that it's perfectly legitimate to, and then we have the passage that's been quoted since about being legitimate. Now, 26, in my judgment, those authorities demonstrate it's perfectly legitimate for the claimant to seek to obtain a judgment of this court on the validity of the patent in suit, in the hope it will lead to a settlement of dispute between the parties throughout Europe, and nor is it improper to show it to the EPO, and it's not an abusive process. But again, it was all spinning off from this action that was to revoke the United Kingdom patent. It wasn't solely, or indeed predominantly, for that purpose when one sees what was said. And I think in that context, it's interesting to see what was said by the court in the context of the alternative application, which was the application for the stay, because it drives home and brings to the fore the UK value of the judgment. At 28, in support of the application for the stay, the defendant contends that the costs of the duplicative proceedings in the present case are not justified given the proceedings are commercially pointless. Then at 29, to that the claimant makes essentially three responses. First, the claimant contends, as I mentioned earlier, the present proceedings are not commercially pointless. On the contrary, the claimant contends there is a very real point in seeking to have what it regards as an invalid patent held in a court of contracting states. Counsel for the claimant argued the licence that had been offered by the defendant simply wasn't good enough for two reasons. First, it was commercially unacceptable because the requirement of the defendant to keep it confidential. He submitted that it didn't meet the claimant's commercial need in a way that the public judgment of this court holding the patent would do. Secondly, he submitted the licence was legally unacceptable because the terms of the licence were insufficiently clear and no draft has been put forward by the defendant, so on and so forth. So basically, there would be ongoing commercial uncertainty. And in 31, so far as the last point, the counsel for the claimant in 30 replied the licence offered was clear and unambiguous, submitted there was no doubt as to its extent of its terms or it met any conceivable commercial need for certainty the claimant might have. So far as this point is concerned, it seems to me the answer lies in the judgment of the Court of Appeal in Glaxo and Genentech, where Lord Justice Mummery said much weight should be given to the assertion by a commercial party that has good reasons for resisting a stay and the contention of a competitor which is that there's no commercial need for early resolution of validity should be viewed with suspicion. The claimant has put forward reasons why it says it needs commercial certainty provided by the judgment, and why it believes a judgment would be of assistance not only to it, not just in providing certainty in the United Kingdom, but more generally. So again, just as in food, beauty and allergy films, certainty in the United Kingdom was at the driving seat in this case, and they basically picked up on a use for export. But that wasn't the sole or predominant purpose. And in those circumstances, there was a UK-centric aspect of the case. It wasn't merely a collateral purpose. Yes, people have been known to export judgments, but the central purpose was the revocation of a UK patent. And Mr. Justice Henry Carr was well aware of that distinction in Fujifilm, and he drew the distinction in 374. Just going back to 374, paragraph 374, page 91, which is where he said, memory, I'll get it right. Yes, he says these have all been statements made in the context of stays or timing. Mr. Justice Burst was also aware of that when he expressed his agreement with Mr. Justice Henry Carr in Pfizer and Roche. So just to summarise all that, in TNS there was an underlying legal right in issue in the UK, the validity of the 860 patent. There was a statutory right being exercised in the UK under Section 71 to revoke the granted patent. There was a real UK dispute, and it is legitimate for there to be spin-off from a UK-centric dispute. That is not this case. I was just going to come on next to the judgment of Drexelmeier.
Well, perhaps it might be convenient to break now and resume at 2 o'clock with that.
Thank you, Lord.
All rise.